The first court date you will appear at, with very few exceptions, is called an arraignment. The arraignment is where you will be advised of the charge, the potential penalties associated with the charge, maximum and mandatory minimum penalties, your rights, and then you'll be asked to enter a plea, which is always not guilty. Then the judge will consider conditions of release. Conditions of release are essentially rules which you have to follow while the case is pending in order to stay out of trouble. Typical conditions for a DUI include do not drink or use non-prescribed drugs, including marijuana. Don't go to places where the primary business is the service of alcohol. In other words, don't go to bars. Stay out of trouble, do not commit any crimes, and appear back in court when you have to. Now, a quick word about these conditions. If you work at an establishment that serves alcohol, tell your attorney prior to the arraignment. It's important the judge permits you to go to your place of work in order to maintain employment. If this exception is not part of the judge's order, you will not be permitted to go to work. All right, well, look, there are times when a court will impose additional sanctions and penalties. These can include pretrial probation, which means you're on probation during the case, an ignition interlock device, a scram bracelet, or even bail. The court may impose such conditions if the facts of your case are particularly egregious, so in other words, a bad accident, a high breath or blood test, or if you have a prior DUI. Now, if you do have a prior DUI, you can expect, at least in the courts I'm in, pretrial probation, and in every court in the state, an ignition interlock device if the present and current case involves alcohol. An ignition interlock is mandatory, in fact, if you do have a prior DUI charge. If you don't have a vehicle to put the device in, well, then you'll need a scram bracelet instead. The next court date is called a pretrial. This court date is when a case can resolve or the case can be continued. A continuance is when we ask for more time so that we can gather more evidence, complete necessary tasks like an alcohol drug evaluation, prepare for motions or even a trial, and importantly, continue to negotiate the case. Now, depending on your case and the court you're in, it is likely you won't need to appear in court at a pretrial if you have an attorney. Now, this is true for all Whatcom County courts, including Whatcom County District Court and Bellingham Municipal Court, and all Skagit County courts, including Skagit County District Court. A motion hearing can be done for a variety of reasons, and depending on that reason, we might have some slight variations of the term. But to keep it easy and simple, I'm just calling this type of hearing a motion hearing. Okay, motion hearings are when we want to argue evidence in a case. Specifically, we want to try and suppress or remove evidence in your case. Successful motion hearings can remove or suppress evidence and even, in some cases, dismiss the case. Typical motion hearings might include a motion to suppress the breath test, blood test, the refusal of a breath or blood test, probable cause to arrest, or even the original contact of the defendant or stop of the vehicle. Probably the most common motion hearing, though, is to suppress statements made by the defendant. Certain motions, such as suppressing a breath test, does not dismiss a case, but removes the breath test, which would certainly improve the case. On the other hand, there are motions that are what we call dispositive, which means they can dispose of a case, so dismiss the case. Such motions that are dispositive would include a motion to suppress the original stop or contact of a person, or that there was no probable cause to arrest for DUI. If your case has been negotiated to a place that's acceptable and you want to enter a plea, well, you have to go back to court and enter that plea. But you just don't show up to court unprepared. Now, I can't speak for all attorneys, but the way I do it is to prepare for the plea with my client at least a day before court, and of course, the day of court. When we appear in court, I always go over the plea with my client at least twice. The first time we go over a plea form is to ensure that my client understands what is in the plea form, what every paragraph means, the impact, of course, and the recommendations that are jointly agreed to. The second time we go over the plea form, I actually pretend I'm the judge, and I go over the plea form with my client exactly like a judge would. And the reason I do this is it prepares my clients for their appearance in front of the judge. Entering a plea is stressful, so my hope is that this removes a little bit of the stress from my clients. And importantly, the idea here is that there are no surprises. Surprises are not good. Now, after a plea, you may need to check in with probation. Of course, you may not need to, but that depends on the result of your case. But if you do, your attorney should prepare you for this. You may also need to check in with the court clerk to set up a payment plan, if in fact it hasn't already been done so in court. If there's jail time or home detention time, you will also need to contact the appropriate agency to schedule this. Now, I won't spend too much time in this video talking about trial, as I think that should be a separate video and is probably overkill for this video. But here is a synopsis of what a DUI trial looks like. First, most DUI cases never even go to trial. Second, when we do go to trial, this means, at least to me, that we have not successfully negotiated the case to an acceptable result. This is usually a disappointment, as I really focus on negotiating a case to a vastly improved result. And I'll talk about that during the negotiation chapter. Third, if the case does go to trial, well, this is a big deal. Trials can be stressful and time-consuming. And the basic idea of a DUI trial is that the government must prove that you have committed the crime of DUI beyond a reasonable doubt. Again, I won't detail the trial process in this video too much, but the government presents their case based on permitted evidence, and the defense offers a defense, or alternatively, argues that the government has not proven their case beyond a reasonable doubt. The presentation of evidence starts with the government and their witnesses. Their witnesses would include the officer or officers that were involved in the case, perhaps civilian witnesses, and even experts, such as a BAC technician and toxicologist. Now, once the government has rested, in other words, have had all their witnesses testify, well, it's your turn, the defendant's turn. Defense witnesses may include you, the defendant, civilian witnesses, and even your own experts. Once the case and evidence has been presented, the attorneys make closing arguments, and then the jury decides your fate. As I said, a trial is usually, but not always, a last resort. If you believe you want to go to trial and you feel this way at the beginning of your case, be sure you discuss this process with the prospective attorney before you hire him or her. You want to know if your attorney is capable of taking your case to trial before you commit to hiring. Some attorneys don't even go to trial, while others might have a schedule issue or conflict at that time and may not be able to even do your trial in the next few months. And you need to know this before you hire the attorney.